Good afternoon, everyone. Thank you so much for coming. The court's ruling today is the culmination of over 5 years of work by NCLA through all levels of 3 federal circuits to vindicate American civil liberties, liberties that have for decades been sacrificed to the illusion of supposedly efficient administrative adjudication. Justice Kagan correctly identifies Michelle Cochran's claims as fundamental, even existential. Justice Thomas's concurrence reminds us that where life, liberty, or property interests are at stake, due process requires courts, with all of their constitutional protections in place, to hear those claims. Justice Gorsuch's concurrence drives a stake in the heart of court doctrine that has forced litigants like Ray Lucia and Michelle Cochran to endure costly, ruinous, unfair, and illogical proceedings that are preordained to be repeated. Today's decision is an exhilarating return to constitutionalism.
Thank you, Peggy. Thank you very much. Mark, do you have a statement at this time?
Well, I'd really love to jump in with any questions that reporters have. I just wanted to commend Peggy for her hard work on this case throughout, and just to note that while this is an important milestone for NCLA and a tremendous victory for Michelle, because it means that she is not going to have to appear in front of an unconstitutional ALJ. It's even more important for all of those litigants in the future who will now be able to raise constitutional objections to unlawful administrative tribunals and won't have to endure the process as the punishment, which is what Michelle has had to endure, what our previous client Ray Lucia had to endure, what our other clients who have had these cases. We had another cert petition at the Supreme Court on behalf of another client in Gibson v. SEC on this same issue where cert was denied. And so this is a long time issue. The Supreme Court got it right. I'm very excited about that. I'm particularly excited for what it means for the future of other litigants against not just the SEC, not just the FTC, but against all of these federal agencies that might be engaged in unlawful administrative tribunals.
Are there any questions from the folks online that we can answer at this time? Well, I know that Michelle Cochran really has been at this for many, many years. And as we'd like to say at NCLA, that the process is the punishment at SEC. Peggy, I don't know if you want to talk a little bit more about that.
Well, I think you're very right, Judy, to bring Michelle to the forefront. And she and Ray Lucia before her, Christopher Gibson, George Jarkissi, the list goes on of people who had the courage and the stamina to change the system is what this kind of victory requires. And so all too often, people just fold and submit to what is a ruinous process. And that's why the constitutionality of the proceedings has not been questioned in so many years, because the process is so exorbitantly expensive and the time for you to get to court is so dreadfully long that these things don't get challenged. And so people lose their constitutional rights over decades of time.
And realize too that even though Michelle won today, and we're very excited that jurisdiction has been found here, all that means is that she now gets to go start her case in front of a federal district court. This isn't over for her, even though she won at the Supreme Court. She's just now, after 4 years of litigation, getting to start at the starting line in front of a federal district court in order to vindicate her rights, because the Supreme Court didn't reach the merits today. They declined to reach the merits of the question of whether or not undue levels of protection from removal for SEC ALJs are unconstitutional. They declined to reach that question in the Lucia case back in 2018. It wasn't presented in this case. They declined cert on that question previously well, that issue was implicit in the Gibson case as well. And then, here we are. We've got a decision on jurisdiction, but we still don't have a decision on the merits. So Michelle's going to keep fighting the good fight here. We will go represent her in the Northern District of Texas. We'll keep fighting this fight. But even this Supreme Court victory is not the end of the road for Michelle.
One of the best expressions of what Mark was just explaining was Justice Gorsuch, who details in exquisite detail exactly what Michelle went through, how many years, this was her second administrative proceeding that she was going to have to face before the SEC, and she instead took them to court. And he has this line in his concurrence that says, "This is what a win looks like." And the win is that she has to go back all over again and face prosecution by the SEC. And this is now, I believe her prosecution was 2016. So we're talking about 7 years. She's been embroiled in this endless process. No one should have to go through that sort of lengthy, costly, ruinous process to have their claims decided by a constitutional judge.
Peggy, I see we have two questions in the queue now, so let me pose the first one to you. The question is, on the merits, should ALJs at the Department of Transportation, the SEC, the FTC, and other agencies be packing their bags?
Well, given how slowly justice has turned in this case so far, I wouldn't necessarily say pack their bags, because the court did, as Mark said, decline to reach the issue of removal. But I do think that the system of administrative adjudication is coming under great scrutiny, and we are before judges in the lower courts as well as at the Supreme Court who are very concerned about the constitutional deprivations that Americans suffer in these tribunals.
And I guess I would add two things to that. First, with respect to Michelle, she's in the interesting position of now having her case remanded to the federal district court in Texas at a point in time where the Fifth Circuit, in the meantime, has reached the merits of the question in her case. In a case called Jarkissi v. SEC, the Fifth Circuit Court of Appeals decided that, in fact, it is unconstitutional to have these multiple layers of removal from protection. So I think it's a foregone conclusion that Michelle wins in federal district court, because there's now on point Fifth Circuit precedent in her favor on that question. I think the question is, what will the Supreme Court do with the Jarkissi case? Are they going to hear that case? What are they going to do with it if they hear that case on that question? And so, that remains to be seen. I think it's good that the issue will be coming up much more quickly, so we won't have the same sort of, well, hopefully will be coming up more quickly, so we won't have the same sort of 5-year interval that we saw between the Lucia and Cochran cases. Pardon me, let me turn that off. The other thing that I wanted to say about that is that to the question about should ALJs be packing their bags, I agree with Peggy. It's a bit premature, but I think that maybe they should be quaking in their boots, because I think the Supreme Court has signaled that they're not happy with the status quo when it comes to these administrative proceedings. They recognize, I don't think Justice Kagan lightly says that that's existential when she talks about the objections that are being made. But we'll have to wait for a merits decision before we can think about any ALJs packing their bags. But certainly it's our hope and our belief at NCLA that these administrative law judges are not just unconstitutionally appointed pre-Lucia, not just unconstitutionally protected from removal, but they're also deciding facts without juries, which is something that the Seventh Amendment doesn't allow. And that was an issue in the Jarkissi case as well. And so we just, and we're not going to rest on this issue until people are able to appear in Article III courts and have their rights decided and evaluated that way. With that, let me jump to the second question, Peggy. Someone asks, if I'm an officer at a company alleged to have to have acted fraudulently, what does this mean to me in concrete terms?
Well, you certainly need to be represented by counsel. And this is a good case to show to your counsel because there are a number of constitutional objections that can be raised in the proceedings below. Michelle raised due process concerns as well as the undue protection from removal by her judge, but also the jury trial claims, which are essential. And the other thing that I think should be on the person's mind here is the deck is stacked against respondents in these proceedings in any number of ways. They're given very short deadlines. After the SEC has had years to investigate them, their time to present a defense is very foreshortened. The SEC gets pretty much all the time at once. It grants itself extensions. These proceedings can go on for years and years. We know of a case where the SEC has given itself 11 extensions of time to decide the case. A process like that, by its very terms, denies people their due process rights. Also, rules of evidence, rules of civil procedure, rules right to confront your witnesses, all of these important, vital constitutional rights are completely eliminated or foreshortened in administrative proceedings. And I think the court is going to be very concerned about administrative proceedings that have those constitutional infirmities.
And I'd like to focus in on two particular aspects of the question. First, you said, if I'm an officer alleged to have acted fraudulently. So let me focus on the word fraudulently and point out that fraud is a common, was a cause of action in common law, right? That's not a new sort of regulatory type violation. And so fraud is something that juries traditionally have decided, certainly in the criminal context. And if there are allegations of fraud, it would be our position that that's something that a jury needs to decide in the regulatory context as well. And it's not something that's beyond the capacity of juries. It's not something that's outside of the historical context of what juries have decided. And so, one of the things that I would very much encourage anyone in one of these administrative proceedings who is accused of fraud to do is assert your right to a jury trial. And that can't happen within the context of an administrative proceeding. So it has to be in an Article III court. Some of these agencies, the SEC is a good example, already have the option under existing law to bring these cases in an Article III court. My advice to the SEC, unsolicited though it may be, would be you better take these cases to Article III courts where you can get a jury and not continue to play this game of trying to go up and down to the Supreme Court. Take your lumps and start arguing these cases in Article III courts. The second thing I want to focus on, you said, what does this mean to me in concrete terms if you're such an officer? I think what it means in concrete terms is if there are constitutional infirmities in the agency that is coming after you in an enforcement proceeding, you should have the opportunity to assert those without going through the administrative proceeding first. That's the by today saying that there is jurisdiction in federal district courts to hear these sorts of structural constitutional claims, that is giving a signal to federal district courts that they should be hearing these claims and not denying jurisdiction.
And to develop a little further Mark's point about jury trials and how essential they are to the findings of fact and to justice for anyone charged in such proceedings. We've had the great support throughout Michelle's and Ray Lucia's journey through these proceedings of Mark Cuban and two other people who were in fact prosecuted by the SEC before juries, and they won. And it is important, I think, for you as someone who's been charged to be sure that you are going to get before a group of your peers who could fairly look at the evidence that is against you. And you have every right to bring all of the evidence in that supports you. One of the things that happened to Ray Lucia is he was not allowed to have witnesses on his own behalf because the SEC served those witnesses with subpoenas demanding their financial records for the last 5 years. That sort of witness intimidation would never be permitted in a federal court.
We have a third question, Peggy, that has come in. The question is, should the SEC ALJ system ultimately be found to be unconstitutional? What effect might that decision have on past or current SEC enforcement actions brought before ALJs? So let's take those separately. Effect on past actions, and then effect on current SEC enforcement actions.
Yes, on current actions, I think what should be the response is exactly what happened when Ray Lucia's decision came down, which is if there's a constitutional infirmity, people have to then recalibrate and bring the proceeding where it would be liable, where it would be lawful. And so that if it was an ongoing proceeding, I think that you'd have a very good argument to get that proceeding moved to a federal court.
Yeah, I would fully expect that if there are folks in other similar proceedings, that they may be bringing actions in federal district court in the coming weeks.
I agree. Now, as far as past claims that were brought in, were not brought in federal court, there's very often not a legal remedy for that.
It's difficult post-settlement for sure, but Peggy, I thought you might want to talk about the little problem that the SEC has with having peeked at each other's papers.
Oh, absolutely. This is fascinating, and we are going to be bringing this to the press attention. Right at the time Michelle's case was under consideration for cert, we received a very interesting filing from the SEC telling us that its enforcement staff had accessed the files of the administrative law judges. That was filed not only in Michelle's case, but in a case called George Jarkissi at the Fifth Circuit. And the Jarkissi case and Michelle's case are two of the biggest cases that the SEC has in the courts right now. And in both of them, they disclosed that there had been file sharing between what was supposed to be an independent and impartial judge and the enforcement staff. We have been trying to get from the SEC for now over a year its records and its report that documents just what happened. Having filed that disclosure, we know we have every right to receive that material. We have filed FOIA requests, and other than getting a copy of a contract of the person the group that they hired to essentially exonerate them, we have had no production. We don't know what happened. And this is just another example of administrative arrogance. They file in two cases that are now headed to the Supreme Court. And Mr. Jarkissi's case is very likely to go to the Supreme Court. And the SEC admits there was file sharing between its enforcement staff and the adjudicators, and yet we're none the wiser as to what happened. And that kind of administrative incompetence and arrogance
And obfuscation.
Yeah, absolutely. And I think it shows that we maintain these are inherently unfair and biased proceedings because, let's face it, your boss, your judge's boss is your prosecutor. Now, what could go wrong with that?
I think you need to put that on a bumper sticker, Peggy. I like that. And the reason I mention that in the context of this question is you're asking about past enforcement actions. I think if the SEC discloses that this kind of conduct was taking place, even in actions where there was already a settlement or already a resolution, that could conceivably create an opportunity to reopen some of those cases. And that may be why the SEC is so loath to disclose how many cases it was peeking at each other's papers in, because we don't know how far back this problem goes or how widespread it was. And forgive me for not being willing to take the SEC's word for it, that they've gotten to the bottom of the problem and that there isn't any more need for anyone to know anything more about it.
Well, there were even congressional hearings on this, and the gentleman that showed up claimed he didn't really know much about the proceedings He hadn't reviewed the report. He made statements that were untrue, such as these were immediately disclosed to the people whose files were accessed, and that's not true. There was a very lengthy period of time between the time the SEC discovered the problem and then disclosed it in these two cases. So the whole pattern of obfuscation and dishonest answers to members of Congress who have oversight, duty, and authority over the agency are deeply troubling.
We have another question, Peggy. The question is, could this case also affect PCAOB proceedings or cases involving other accountants before the SEC?
I think the answer is yes.
Yeah, absolutely. And in fact, NCLA has a lawsuit in the works against the PCAOB. So stay tuned for more information on that. One of the interesting things, and this isn't something that isn't public yet. It's on our website, that lawsuit. The interesting thing, in fact, I think it was earlier this morning, I believe the government filed, their PCAOB filed its motion to dismiss in that case, Peggy, unless I'm getting it confused with one of our other cases. But the interesting thing about that is that the PCAOB, I believe, is this the case, Peggy? I believe it's the one where they hired former Solicitor General Don Barilli to represent them.
So. Yes, yeah, that's the case. Yeah, which
is pretty interesting to me. So they must take the threat to the PCAOB pretty seriously as well. The filing I saw this morning had 13 attorneys from 3 different firms listed on it in response to our complaints. So
there's your government at work, because trust me,
these are all private attorneys too. So.
Yeah. So your tax dollars are going to pay outside lawyers to mount a massive defense of an agency. And one of the things I learned, which I was shocked when I started doing this work, was when you walk into a proceeding before the SEC, typically they have this whole cadre of lawyers. You come in with your lawyers, and they've got 6 there, or many lawyers. And for some reason on this PCAOB case, in addition to their very largely staffed teams that prosecute these cases, they've had to reach for outside counsel. I do think that suggests grave concern about the constitutionality of these proceedings.
And I see in the chat that someone posted that Russ Ryan, our colleague who's running that PCAOB case, said to a reporter today that we believe today's motion lacks merit and we intend to respond accordingly. By unhappy coincidence for the PCAOB, much of the motion was undercut by this morning's Supreme Court decision in the Axon Cochran case. So that's not only could this case affect PCAOB proceedings, it's going to affect the case that we have against the PCAOB right now. Yeah. So that's fun.
As well it should.
One of the wonderful things about working with people like Peggy and Russ is that they're working on cases that are so important and of such moment that we have been able to rely on our own precedents that we have created, even in the 5 years that we've been around, in bringing our next set of lawsuits that we bring. And we have almost 50 lawsuits going right now as we speak. Some of those are making their way up to the Supreme Court. For example, we had another en banc another en banc victory in the Fifth Circuit. The case we're talking about today, the SEC v. Cochran case, is one that Peggy won en banc at the Fifth Circuit. We have another case, Cargill v. Garland, that our colleague Rich Samp won en banc at the Fifth Circuit, that the Department of Justice has has filed a cert petition seeking Supreme Court review of that decision, which involved the illegality of bump stocks. So that may be the next Supreme Court case that's in store for NCLA. We'll see. One of the things, Peggy, that I want to be sure to do before we run out of time here is extend our thanks to Greg Garr and his team at Latham and Watkins for the terrific work that they did. Greg argued, as I mentioned, Peggy won this case en banc at the Fifth Circuit. We enlisted Greg Garr's pro bono assistance at the Supreme Court to argue this case on Michelle's behalf. And we were thrilled that Latham and Watkins and Greg Garr were willing to do that. We think that he did a phenomenal job. And I think today's outcome is testimony to the terrific job that Greg and his team did. I don't know if you want to add anything to that, Peggy.
I do. We also need a big shout out to all of our wonderful amici. I mentioned Mark Cuban, but we have had Amica Support in this case throughout. I think we had 10, maybe 10 briefs, and I think in terms of actual parties on the brief, more in the realm of maybe 13 or 15. And these briefs are important because they develop ideas and talk about different aspects of how unfair these proceedings can be. And they are huge contributors to courts understanding these important constitutional questions. So thank you to every one of our dear friends.
Absolutely. And if you haven't, we're focused on the decision today, which was unanimous and by Justice Kagan on behalf of the court, and which walked through the Thunder Basin factors and why those militated in favor of granting jurisdiction to Michelle Cochran. But I would encourage any reporters to be sure not to miss Justice Thomas's concurrence and Justice Gorsuch's concurrence in the judgment, because both of them delve into additional levels of detail. Justice Thomas in particular is concerned, I think, more deeply with the entire project of administrative adjudication and the problems that creates. Justice Gorsuch is concerned with what are we doing with these Thunder Basin factors to begin with, and this was evident from the oral argument where he kept asking counsel, well, doesn't the statute settle this question? 1331 gives jurisdiction, nothing takes that jurisdiction away, end of story. Why do we even need to talk about anything else? And you saw that in his concurrence in the judgment where he said, we could have decided this case just based on the statutory analysis alone. We don't need these judicial balancing test factors thrown on top of here. And you see what happens when you have these judicial balancing factors. That's what led Justice Gorsuch to say what Peggy referred to earlier, that this is what a win looks like, that you have district judges making the wrong decision and Fifth Circuit panels making the wrong decision. And it took an en banc Fifth Circuit to finally get it right. And the Ninth Circuit got it wrong below. And why? Because these factors stink and they're very hard to apply. And lower court judges have a difficult time reaching a correct result applying these factors. Well, what did the Supreme Court do? It applied those factors in favor of Axon and in favor of Michelle Cochran. And that's important, don't get me wrong, because it's a signal to the lower courts that they have been misapplying these factors in many cases. But it would be better to have a clearer solution going forward. And I think Justice Gorsuch speaks eloquently to that in his concurrence in the judgment.
Another comment that was great at oral argument, and I'm not sure which judge asked this. It was, how long has this been going on? And there's, by the way, a great American Standard song by that name, and I think we maybe we'll use it as background music in talking about these cases. But I was
going to say, don't tempt Peggy; she'll start singing from the American songbook.
Well, it's a very, very important insight when the justice said, how long has this been going on? Because it's not just this particular litigant who Michelle's at her 7th year. It was 8 years for Ray Lucia, 10 years for David Bandemir. It was George Darkesy was 7 years. I mean, these are appalling.
And still counting in many of these cases, still counting for Michelle, still counting for Christopher Gibson, still counting for George Darkesy. These cases aren't over yet. And
then to take it another level up, these unlawful administrative adjudications have been going on for decades. So this is a time to ask, how long has this been going on, and all the more reason why we need to stop it.
Peggy, I don't see any more questions. Do you have final thoughts?
No, it's just a happy day.
A happy day indeed. Thank you, everyone, for joining us. We appreciate your interest in NCLA and in the SEC v. Cochran case. And if you think of other questions that you would like to have answered as you're putting your stories together, be sure to reach out to Judy Pino, and I'm sure she'll be able to get answers for you from our team.